Colt versus New Jersey Transit. Counsel?
Thank you, Your Honor. Good afternoon. Catherine Pringle, together with my colleague Scott Henney of the firm Friedman, Kaplan, Seiler, Edelman, and Robbins for the appellants, New Jersey Transit, and Anna Hernandez. And I would like to reserve 5 minutes of my time for rebuttal.
Yes.
The jurisprudence of sovereign immunity was significantly altered by the Supreme Court's recent decision in Franchise Tax Board versus Hyatt. Applying the substance of this case for the first time, the appellate division made a clear error in its application. The appellate division found, correctly in our view, two things: that New Jersey Transit is an arm of the state entitled to sovereign immunity.
Well, was the arm of the state fully litigated below?
Yes, Your Honor, I do believe the arm of the state was fully litigated below.
How?
Pardon me?
How?
In the motion to dismiss the case under sovereign immunity, the matter was briefed and addressed by the appellate division.
In your moving papers, you had one paragraph that cited to Carnes. Do you think that's enough of a record for us to make a determination about arm of the state?
In addition to citing to Carnes, we cited to a whole series of issues in New Jersey which lay out all of the indicia of why New Jersey Transit is an arm of the state. And if you'd like me to turn to that now, I will.
Oh, I'm sorry, before you do, where is that in the record that you did that in the Supreme Court? Where did you lay all this out?
It's in the brief here, and the court can take public notice of the record of New Jersey's statutes and prior holdings which control on this issue.
So Carnes is what, 2020
I believe so, Your Honor.
around,
2018.
or 2018? Has anything changed since then?
Well, let me back up for just a moment in terms of the
I guess my follow-up is, how would we know, since you didn't address it at all in your papers in the Supreme Court?
Okay. What has changed since Carnes is the Hyatt opinion.
No, I understand that Hyatt changed the law. I'm just talking about the facts surrounding whether or not the entity is an arm of the state. So that was a 2018 decision, or 2018 to 2020 range. None of that was briefed. You cite Carnes, but you don't say whether or not those factors remain the same, right? The statutes to the regs, to the way we interpret them change over time. Why is that argument never made below?
The decision that controls in this case is not Carnes, but is Muhammad versus New Jersey Transit and the Public Transportation Act of 1979. New Jersey itself defines the New Jersey Transit as an arm of the state.
Can I stop you there for a second?
Yes, Your Honor.
So where does the sovereign immunity, is that controlled by federal law?
After Hyatt 3,
Yeah, after Hyatt.
it is not a matter of federal law under the series of decisions that arise under the 11th immunity.
Correct. But is
It
it
is-
nevertheless a matter that is ultimately a question of federal law?
It is ultimately a question of the full faith and credit clause of the Constitution. That provides that this court sitting in New York must give full faith and credit to the decisions and judicial acts of the New Jersey court and legislature.
Wait, I'm sorry. So your view is that the sovereign immunity of states comes from the full faith and credit clause?
No, Your Honor.
So that's what I'm trying to get at. Where does that come from?
The New Jersey's right to sovereign immunity arises as a basic right that it had prior to the Constitution and was preserved in the Constitution. That's what's recognized in...
And so that's then a federal question?
Is it pardon me, Your Honor?
That's determined by federal law,
It is determined by federal...
constitutional law.
It is determined by federal constitution law, but as applied in this court, sitting in New York, the role of New York is to give full faith and credit to the decisions of New Jersey, both through its legislature and through its highest court, in proclaiming that New Jersey Transit is an arm of the state.
Can I ask you to back up a little bit?
Certainly.
It seems to me that your analysis assumes that arm of the state is the proper test. Is that your position?
Yes, Your Honor, I believe
Okay.
that arm of the state is the proper test for the sovereign immunity of New Jersey Transit.
And I want to understand why, because it seems to me that clearly under the 11th Amendment precedent, that has been articulated and applied. But perhaps there's an argument that the scope of interests that are protected by state sovereign immunity are broader than the specific fiscal interests that were at play with respect to the 11th Amendment. And so why is it that we should assume that the correct test for whether New Jersey Transit can invoke sovereign immunity is the arm of the state test, as opposed to going back and looking at what Hyatt tells us about what interests state sovereign immunity is intended to protect?
I think that's a very good point, Your Honor. This case does not arise under the 11th Amendment. It arises under that fundamental sense of sovereign immunity that was preserved by the Constitution. And so there is this body of law that talks about when a state agency can invoke that sovereign immunity. But here, we're not bound by that series of 11th Amendment cases. And so to your point, I would point the court's attention to the Federal Maritime Commission versus South Carolina State Ports Authority case. In that case, decided in 2002, there was no financial issue. The Maritime Authority has no ability to impose financial consequences on the state. And nevertheless, Justice Thomas in that opinion said that what is fundamental is that the state's sovereign immunity is at issue, and therefore whether or not there's a financial impact on the
But
Treasury.
does that, I don't mean to interrupt you, but does
Right.
that tell us what the correct test for ascertaining whether an entity that is not the state qua state is covered? I mean, perhaps one might take the position, for example, that to the extent that the 11th Amendment is more specifically concerned with the impact on the state fisc, that the emphasis on funding that we see, whether you look at the Second Circuit or the Third Circuit, whatever test you use under the 11th Amendment, might be a little off base. So I'm just trying to understand what the right test is.
I think that is a very perceptive question. The Supreme Court in Hyatt does not tell us what the right test is. But what they do is to emphasize the importance of sovereign immunity to the states and the way in which the states came into the constitutional compact with their sovereign immunity intact and continue to have that sovereign immunity.
Would you agree, though, that the Constitution in some ways erodes the sovereign immunity of the states?
Yes, Your Honor, it does in the sense that in entering into the constitutional pact, New York, as held in the Hyatt 3 case, gave up its right to deny sovereign immunity to its sister states, as did New Jersey with respect to New York. So it both preserved the ability of the states to assert their sovereign immunity and also limited the ability of the states to deny sovereign immunity to their brothers and sisters.
Let me ask you then a much less theoretical question. Supposing New Jersey instructed New Jersey Transit drivers to enter New York and deliberately run over pedestrians.
Correct.
Immune?
I'm sorry?
Immune?
First, let me just be clear that there's no
I
record in
understand.
this case.
This is right.
al-
Who would
akin
do
to
that?
So
But
recognizing
there's a
that,
difference between intentional torts and negligent torts, and I'm asking whether you have a view as to whether sovereign immunity cuts differently as to one of those things.
in a case where New Jersey intentionally sought to murder the citizens of New York, for
Yep.
example,
By bus driving,
pardon me?
by driving buses.
By driving buses. There would certainly be an action by New York against New Jersey for which the Supreme Court would have original jurisdiction. That would
Suppose
be
they just
one
did it
clear
one
way.
time. Suppose they did it one time. They
Then
instructed a particular bus driver to run over a particular pedestrian.
I think there would be a question of whether that particular bus driver has liability under the argument that they were not acting as in their official capacity.
Well, there's an instruction from the director of New Jersey Transit to seek out a undesirable New York movie director and run him over.
There again, I think this would be a case that New York could bring against New Jersey in the original jurisdiction of the Supreme Court. I do not have an answer, and I do not think that the particular decedent's family would have the right to sue New Jersey in the New York case.
Because of sovereign
court.
immunity.
because of sovereign immunity. Certainly, they could sue New Jersey in the New Jersey courts.
Only to
And-
the extent New Jersey chose to allow that.
Correct. But here, New Jersey has, as a general matter through its Tort Claims Act, waived its sovereign immunity to allow such suits.
With
Counsel, I'm sorry, to go back to Judge Halligan's point, the difference, potential difference between an 11th Amendment analysis and an interstate analysis, immunity analysis, would, and I think you're pointing to the fiscal issue, and perhaps that would have less weight in an interstate, and I think that's the suggestion of that case, South Carolina. What else? Would there be any other factors that would weigh differently in an interstate analysis as opposed to an 11th Amendment analysis?
I don't think we have got enough guidance to answer that question specifically, so let me draw your attention to 2 points. First, if you look at each of the different tests that the appellee spends a lot of time in their brief talking about, they really come down to the same thing. Does the agency at issue appear by external indicia to be acting in the same manner as the state? So we can talk about all of the indicia that are at issue here, but I think the test is less relevant because those tests all come down to essentially the same thing.
And those would be the same under either analysis, under 11th Amendment, under interstate analysis.
My first point is that those would be instructive to the correct test. But my second point is that you need to come back to first principles of what is the point of sovereign immunity. And the point of sovereign immunity comes back to this question of whether the state would be, should be hailed into a different state in order to answer for its official acts. And here, that's
But does that
inappropriate.
generally make the bar higher on an interstate analysis, or does it cause us to weigh the factors differently?
I think what it does is it causes this court to focus first and foremost on the dignity of the state. Here,
These are so abstract, though. So if we're looking at that, I agree, as an abstract matter, the dignity of the state may have a different perception in an interstate. I'm being hauled into court in Newark, New Jersey, or I'm being hauled, I'm in a state court next door versus I'm in New York State Court in a different jurisdiction with different rules. How does that practically play out when we apply whatever test we think is appropriate to these facts?
sure. Here, New Jersey has made a substantial investment in the transportation of its people, both within New Jersey, primarily within New Jersey, but also in order to deliver its workers to the important cities of New York and Philadelphia. It subsidizes that. It makes it part of its legislative body, executive branch.
On that
Sorry.
point, if I can, my understanding, but correct me if I'm wrong, is that the New Jersey statute allows for funding of NJT from various entities, including the state. But I'm not sure I saw in the record any specific evidence that New Jersey Transit is in fact funded by the state. Is there something in there that you can, and if so, what amount, what proportion of the budget? Is there anything in the record that establishes that?
I would point your attention to New Jersey Legislature Senate Bill 3137, the Public Transportation Act of 1979.
Is that an authorizing statute or an appropriating statute?
That, I believe it's an authorizing
Right.
statute.
So-
But what it makes clear is that the New Jersey Legislature always contemplated that New Jersey Transit would be dependent on state funds. And it has since that time always provided funding to New Jersey
But
Transit.
that latter point, I take it, is not specifically established in the record, what the amount of the funding is.
It does not I don't believe we have the specific amount of the funding in the record. I would point your attention to the district court decision in Worrell versus New Jersey Bus Operations, holding that New Jersey Transit is financially dependent on the state and that a judgment against New Jersey Transit will have a significant financial impact on the state of New Jersey.
And just one last, if I can, follow up. I think that the federal circuits have pretty uniformly held that the burden to prove that an entity is the arm of the state lies with the entity seeking to invoke sovereign immunity. If we were to follow that, then what do we make of the absence of a specific, piece of evidence in the record? I take it your argument then is that the determinations in the district court decision you pointed me to would be sufficient. Is that right?
I think it's sufficient, given the diminished role of the impact on the fisc, to the overall question of whether New Jersey Transit should be considered an arm of the state. There's plenty of evidence that as a practical matter, New Jersey Transit, which is prohibited from issuing bonds or incurring debt, must seek to recover from the New Jersey legislature the amount of money that it needs to fund its operations and its deficits. So if, for example, New Jersey Transit were hit with a large number of personal injury suits, it would have to turn to, and as a practical matter does turn to, the people of New Jersey to fund that deficit.
I'm sorry, I thought the statutory framework did not allow for the state to be liable.
It does not allow
It's
for
a
this.
discretionary determination upon a request to refill the coffers of New Jersey Transit?
Yeah, the law is clear that New Jersey Transit is not, sorry, the state of New Jersey is not directly liable. That is correct. However, New Jersey is indirectly liable because New Jersey Transit is not permitted under state law to run a deficit or to issue bonds. Therefore, if it's in a position of having to pay out a substantial judgment or judgments, that money ultimately comes from the subsidy that is regularly provided by New
The
Jersey.
red light is on. Could you just, for 30 seconds, address the waiver issue?
Certainly. The appellate division correctly held that the New Jersey Transit did not waive, either by its actions in this case or by its actions in the state, its right to sovereign immunity. So first, its actions in this case. New Jersey Transit raised in its answer the defense of sovereign immunity.
Well, it said immunity. Wasn't specific. So if you really believed you had sovereign immunity, why sit on your hands for a couple of years?
Your Honor,
Why make discovery demands on the other side? Why comply with discovery? I'm confused as to why an entity that is trying to protect the coffers of the state would incur so much cost if it really has a sovereign immunity defense that it believes it can assert and succeed on.
yeah, I understand what you're saying, Your Honor. Here, the case originally arose before the Hall decision, pardon me, before the Hyatt decision. And so here, New Jersey Transit did move after the Hyatt decision.
But more than a year after, right?
It was close to a year, yes, Your
I
Honor.
think it's May and you move in July. the
Were there
following.
other motions
There
made
was,
during that period of time?
no, there were not other motions made during that
Was
time.
discovery
There was some
proceeding during
limited-
that time?
I'm sorry?
Was discovery proceeding
Yes,
during that time?
there was some limited discovery, but at the time that the motion was made to dismiss, discovery was still open, there had not been a pretrial conference, and there had not been a trial. So that's in clear contrast to a case like the Henry case that this court had.
But I'm sorry, as I understood your argument, it's a legal issue that you could have raised without discovery being completed, correct?
Yes, Your Honor, I'm not denying that this could have been brought earlier. What I am saying is that in the posture of this case, the time that they brought it would not meet the Supreme Court test of an explicit and unequivocal waiver of the New Jersey's right of sovereign immunity.
Is that counting from the answer or when Hyatt is decided?
I think you need to count from both to some degree.
So what are you referring to in the answer?
I'm
It's
sorry?
sovereign immunity, that's what you claim, not using the word sovereign nevertheless refers to sovereign immunity in the answer?
In the answer, the question of immunity was immediately raised, which, whether or not the
Yes.
word sovereign is, I think the
Okay,
understanding
but let's
is that
assume
sovereign
that's,
immunity.
let's assume that's, I think there are other understandings, but let's assume that's how you wanted to proceed. It makes it a harder case for you. I don't understand why you're sitting and waiting even longer.
To answer your question, Your
Yes.
Honor, it is true that a motion could have been made earlier, and I'm not going to deny that. However, what the Supreme Court requires for a waiver is an express and intentional and clear waiver with every potential ambiguity being construed against waiver. It's one thing in something.
But if you're claiming immunity in the answer, and then you're not making the motion until after the statute of limitations applies, I believe that's the chronology, it does begin to look a little bit more problematic, let me put it that way, from your side, to have waited so long.
It's different, for example, from the Henry case, where the question was raised in the dissent in that matter of whether there had been some kind of improper maneuvering by waiting until after the actual trial and resolution. That wasn't the case here. And so I understand the point if someone waits until after the trial. I don't know how that comes out. But in this case, it was the motion to dismiss and the waiver issue was fully briefed, or excuse me, the sovereign immunity issue was fully briefed before there was a pretrial conference and before there was a trial. In light of the high standard for waiver, no waiver should be found.
I make it the last question. I know the red light is on. I don't want the chief judge to pass me a note or to otherwise interrupt me. Let's say it takes 10 years to get to trial. Does that make a difference?
Well, I would look
It
at
seems a long time to sit and wait.
I understand what you're saying, Your Honor, but look at, for example, at the Hyatt case. So first of all, this is not 10 years, but look, for example, at the Hyatt case. In that case, poor Mr. Hyatt litigated for almost 20 years, 19 years with 3 trips to the Supreme Court. He recovered a judgment of $500 million against the state of California. So clearly he had been abused by California in Nevada. Nevertheless, the Supreme Court found that the sovereign immunity issue was much more important than those specific costs to Mr. Hyatt. And so our case is nothing like Mr. Hyatt. This is a much more condensed time frame. And the constitutional principle is what really matters and needs to be enforced by this court. Furthermore, if you're looking for a clear rule, it's difficult to say that, you have to move within a month or you have to move within 3 months. I think it is a much clearer rule if you suggest that there's potential for manipulation if it's done after trial, but before trial, there's no such indication of manipulation. And one further point, there's no indication that Mr. Colt could not refile his case in New Jersey, given New Jersey's rule of equitable tolling.
Thank you.
Thank you, Your Honor.
May it please the court, I'd like to pose a hypothetical, if I may. A New Jersey Transit bus drives into Manhattan, one of hundreds that do so each year. Along the way, it strikes a pedestrian, causes property damage, and violates some traffic regulations, maybe a VTL provision. And the position here is the injured pedestrian or dead pedestrian can't bring suit in New York. The landowner can't bring suit in New York. And the traffic regulation can't be charged in New York.
Let's say in your hypothetical, it is New Jersey. There's no question it's an arm of the state. New Jersey decides they're not waiving sovereign immunity at all, ever, not anywhere, not New Jersey, not anywhere else. You would still say they could be sued in New York?
No, Your Honor. I'm saying they can be sued in New York because they are not New Jersey and because New Jersey waived whatever sovereign immunity this entity would have had. Let me start with the arm of the state. Judge Singas asked, well, there's hardly any record here in terms of this entity's activity.
I would say the same to you, the flip side of the coin. Your opposition papers don't talk about, in fact, the arm of the state is nowhere in the papers. So I'm troubled by the thinness of this record, frankly.
This was pages 29 to 30 of our brief. Every circuit that has addressed the issue says that the burden of establishing that the entity is an arm of the state is on the entity that claims to be an arm of the state. The fact that it's produced zero evidence doesn't make it harder.
Do you make the argument even that they failed to meet their burden, that they weren't an arm of the state? Like, I don't see that in your answer.
They're not an arm of the state. Let me.
You make several specific arguments in answering the motion tied to the act and tied to some other things, waiver, I think, but you never even put in an answer to the motion saying they failed to meet their burden to show that they're an arm of the state.
Your Honor, we briefed this at length in the appellate division
No,
on
no, I'm
both
not talking about
sides.
the appellate division, I'm talking about the motion court.
No. The only showing that they have is an arm of the state, is they, as you mentioned, Judge Singh, is they cite a case. And we're suggesting, Your Honor, that simply they are not. They're not an arm of the state. And what they, and the proof that they could have produced or didn't produce is secondary. Doesn't matter. And the reason why it doesn't matter is they are simply not legally an arm of the state. I'd like to tell you why.
So you're saying that they could not establish, with whatever proof, that they're an arm of the state?
Because the New Jersey statutes, which they failed to cite, foreclose it. And let me explain why. As you're aware, in our brief, the United States Supreme Court has 5 times, 5 different cases addressed what is and what is not an arm of the state. The last couple were Hess versus Port Authority and Regents of California versus Doe. However, in all that time, they've not articulated a clear standard, a clear test. They've stated principles, with the result that every single circuit now has its own arm of the state test. The Second Circuit has one, the Third Circuit has one, the Ninth Circuit has one, they're all different.
Those are in the 11th Amendment context, correct?
I'm sorry, Your Honor?
Those are in the 11th Amendment context?
Yes, they are. And in fact, this is a whack-a-mole. In the appellate division, the claim was that they are an arm of the state under the 11th Amendment. But then when we come up with case law and statutes showing that they just are not, then it's no longer under the 11th Amendment.
But if we need to determine, or we might want to consider determining what the right test is to figure out if there is sovereign immunity following Hyatt, why is it that the 11th Amendment arm of the state test is the one that we should use? Because I think, even following Hyatt, it's probably the case that the 11th Amendment protects a somewhat narrower set of interests than state sovereign immunity generally does. So why is the 11th Amendment test the right test here?
2 points with respect to that. The one issue that Hyatt doesn't address at all, just doesn't address it because it wasn't that issue there, is this entity the state or an arm of the state? It was clear it was.
I agree. It doesn't tell us what the test is.
There has, to my knowledge, been not a case, nor has one been cited, where a court has said the test is different from the, for interstate immunity.
Has this come up, though, post-Hyatt, the question of what test a court should apply to determine whether an entity that wants to invoke sovereign immunity but is not the state qua state is able to do so, and whether the 11th Amendment jurisprudence applies?
Every court that has addressed it, post-Hyatt or pre-Hyatt, has used 11th Amendment case law, including the Gillette decision last year.
Well, it seems to me maybe Hyatt changes the landscape a bit, so that's why I'm asking if there are cases post-Hyatt that you can point us to.
Not really, because Hess, the Supreme Court decision in Hess, states quite clearly that there are twin reasons for being on the 11th Amendment, fiscal and the state's dignity. There's never been a suggestion that it's different for interstate.
So then is your understanding, let me put it that way, of Hyatt 3, that it sweeps more broadly than the prior jurisprudence under the 11th Amendment? That is to say that the state, as the state, of course, New Jersey is New Jersey, and in addition, perhaps other entities fall within this rubric of Hyatt 3 that would not fall under the 11th Amendment, or is it in reverse?
Your Honor, Hyatt doesn't address the issue at all. I mean, it's just.
No, I'm asking you what's your understanding. If you were going to interpret that and say, yes, under Hyatt, let me put it perhaps more crassly, there's more potential defendants than there would be under the 11th Amendment jurisprudence. Or do you view it in reverse?
I suppose so, but I think the interests in not appearing in a sister state's courts are the same, whether it's 11th
Well, then, are we
Amendment.
bound by New Jersey's judiciary's own interpretation of whether or not New Jersey Transit is an arm of the state or otherwise functions as the state for purposes of the services that it is rendering.
Statutorily, Your Honor, they are not an arm of the state.
I didn't ask that. That's not what I asked. I'm asking you about whether or not this full faith and credit argument or some version of it binds us so that we are locked into an outcome on this question. About
Your
whether
Honor,
or
I
not they can
find-
even invoke, this question at its core, as I understand it, is whether or not they can even invoke and draw the benefit of sovereign immunity.
I find the full faith and credit argument positively Orwellian
Okay.
in this sense. You can search for a statute from New Jersey or a Supreme Court holding from New Jersey stating that this entity has interstate immunity. You can search for a statute that says that they haven't waived their immunity. You won't find it. But what you will find is in the very law under which this suit is brought, the New Jersey Tort Claims Act, not some other area of the law, the term state is defined in this law, 59:1-3. State is defined. It shall mean the state and any office, department, division, bureau, board, commission, or agency of the state, but shall not include any such entity which is statutorily authorized to sue and be sued. They've, by definition, ruled it out. Now, there's one exception here. The exception is the Palisades Interstate Park Commission. And with respect to that exception, there's an exception. That's accepted, but only with respect to employees' property and activities within the state of New Jersey.
Ask you about that. Is it your position then that, given that what you just shared with us, that if the record established that the state of New Jersey funded New Jersey Transit to some meaningful amount, and also perhaps was liable for judgments, that there still would not be, they wouldn't be an arm of the state? Is the statute the only factor in your view?
Well, that's what I was talking about, Your Honor, full faith and credit. The only way you could find they're not an arm of the state is by not giving full faith and credit to the definition.
So your
Now,
view is that the statute then that you just shared with us is the only factor that's relevant, notwithstanding funding or anything else?
No, there are other statutes too.
But let's
For-
say the Jersey Supreme Court interpreted those statutes differently. Let's say the Jersey Supreme Court looked at that statutory landscape, heard all these arguments, and this is a hypothetical, and said, they're an arm of the state. Could we then look at the statutes ourselves and say, no, that statute doesn't mean that? This is a
Your Honor,
hypothetical
in the nature
question.
of the New Jersey Supreme Court would never look at it, could never look at it, because it arises.
I'm asking you a hypothetical
No,
question.
I-
Let's say they
hypo-
did.
There would be no occasion. The reason being, the issue arises only when they're sued in the courts of another state. So when would the New
All right,
Jersey
so, but we
Supreme
can
Court?
change the hypothetical a little bit to get at what Judge Rivera, I think, was trying to ask you. Suppose the New Jersey legislature amended the statute you just read to say New Jersey Transit is an arm of the state. Then do we have to give full faith and credit to that statute,
That would be a factor to consider.
but not dispositive?
No, because under the test of any circuit you choose, one of the factors is how does the state itself denominate this entity? Another factor is, and it would change the analysis under the federal law, another factor is, would a judgment against this entity affect the fisc of the alleged arm of the state?
These are, again, you're back to 11th Amendment tests, I think, right? And let me ask you if you agree or disagree with this. Hyatt, I think, identifies two sources of the interstate sovereign immunity. One is common law, and the other is law of nations. With me so far?
Yes.
Okay. That is perhaps different from the source of 11th Amendment immunity, which was a reaction to Chisholm just after the Union had been formed, the United States had been formed, where the question really was, did the states intend to create a federal judiciary that would be able to hear cases with states as a defendant? Those seem to me two very different sources that might have two very different purposes. Maybe not. But if they are, then I'm not sure why you would resort to the 11th Amendment cases or factors at all.
The reason I'm resorting to the 11th Amendment cases is essentially that is all we have to distinguish what is a state or an arm of the state for the purposes of sovereign immunity from what is not. And,
But if
and
there are
it's
two
possible.
different types of sovereign immunity, that really, 11th Amendment sovereign immunity it's often phrased that way, but it really is a disability of the federal courts to hear a certain type of case, right? That's actually the way the amendment is worded.
Yes, but the purposes, the twin purposes of its being, according to Hess, are to save the state's fisc, which would arise only if the state is going to be responsible for the judgment against the so-called arm, and to preserve the state's dignity. And I don't think there are any other purposes that could be served by interstate immunity other than financial and dignity.
But to that point, as I think that the chief was suggesting, the reaction to Chisholm, I believe, was focused on concerns about debts that the states had. And so the focus on the state fisc, I think, was paramount. And that is, I think, why you see such a focus on questions about funding and liability in the 11th Amendment jurisprudence. But the sovereign immunity that is laid out in Hyatt seems to me to perhaps be focused more broadly, and to be focused, for example, on questions about setting aside any monetary impact. What is the consequence, is it indignity, of hailing one state into another state's courts? So the test might be different because the underlying concerns and objectives of the immunity might be different, no?
But when you go down that road, I think you ultimately end at the destination that you're going to have a different test for a New Jersey entity depending upon whether they're brought into the Southern District, New York, or New York Supreme, and the test would be different in each, if you go down that road.
But I don't know if that
Well,
would
the
be
test
true.
is different, 11th Amendment or sovereignty. That's the point.
Yeah.
Yes, you're right. It might depend on the court, what decision they make as to which one they want to assert. But I'm just circling back. If indeed New Jersey has announced to the world that New Jersey Transit is us, right, is New Jersey, we believe we're in a symbiotic relationship here, and they are appropriately able to invoke sovereign immunity, can this court hold otherwise?
Your Honor, but the New Jersey has done the exact opposite. They've defined in the law that we're suing under.
Let's say we don't agree with you on that. Go to the question I've asked. I mean,
I'm sorry,
maybe you answered it, I missed it, so I'm just asking it again.
Okay.
Can we hold to the contrary?
New Jersey has never held that this is an arm of the state. In the case that was cited by my adversary, Mullen versus New Jersey Transit Corp., they said the opposite. When you look at the definitions, there are public entities and there's the state. Those two things, they're both defined in the Tort Claims Act. A public entity is basically any governmental entity. Every water authority, every town, and every village, et cetera, they're a public entity. That they're a public entity doesn't mean that they're the state. And in fact, that's what the Mohammed Court said, that they're a public entity, which they are, doesn't mean that they're the state. And if you look nationally at the entities that have been deemed arms of the state, if we're looking at transportation authorities and common carriers, this isn't the only one in the United States. There are two others that were deemed arm of the state. The Alaska Railroad Company and the Washington Metro Authority. In each instance, the Hess Court observed there was a reason for that these were thinly capitalized ventures where a judgment against one of these entities would be funded by the state because they were thinly capitalized. If you look on the other side, the great majority of these entities have been deemed not arm of the state, not subject to sovereign immunity. New York State Thruway Authority, not an arm of the state, Second Circuit. Puerto Rican Port Authority, not an arm of the state, First Circuit. Golden Gate Bridge Highway and Transportation District, not an arm of the state, Northern District, California.
And in
Dallas-
those cases, is it the fiscal considerations that are paramount?
Well, each of them applied their own circuit's test. But as was said, those tests are similar in that they're framed differently, but they all look at the fisc. They all look at the amount of control over the entity.
Which test would you advocate for?
Your Honor, the Second Circuit, but actually it doesn't matter. Because even if you apply the Third Circuit's test, and you consider the statutes which were not cited to the Carnes Court and which it did not find, you end up at the same result. This is not an arm of the state. Dallas Area Rapid Transit, Southeastern Pennsylvania Transportation Authority, Metropolitan Bus Authority. That
So
was
let me ask you, let's say our ruling allows you to move forward in New York, and you win. Who's paying?
New York, the New Jersey Transit Authority. As a matter of statute, they will not be reimbursed. They will not be reimbursed because one of the statutes...
Where are they getting the money from?
They get the money from their own coffers. You know,
You mean from what they charge the ridership?
Yes. My adversary just cited as
And
evidence...
if that's not enough for them to continue in business, does New Jersey have to pay for the rest of it?
No. As a matter of statute, they're not going to pay anything. As a matter of statute, 25-17, they are not liable. The state is not
Well,
liable.
I understand that, but my question is a different one about the shell game of money. So if in response to me, you're saying, well, New Jersey Transit has to pay it out of whatever their coffer is, that's separate from money that came directly from the state, that's going to leave them with a deficit somewhere, right? Because they're paying you. Doesn't New Jersey have to make that up?
Let me give you the Third Circuit's answer to that very
Yes, please.
question. You had just cited the case of Worrell as evidence that they're subsidized by the state. Worrell is a 1980s trial-level case. Subsequent to Worrell, the Third Circuit twice addressed the issue that you're talking about. Where does the money come from? And in the first case, Fitchick versus New Jersey Transit Authority, the court concluded what was remarkable about the finances of the New Jersey Transit is how little money came from the state. And then in Carnes, where the Third Circuit looked again, what the court said is back in Fitchick, we said that this is not subsidized by the state, and no one's provided any evidence to cause us to believe otherwise. The reason that the Third Circuit nonetheless deemed them to be an arm of the state was they weren't aware, it wasn't cited to them, or at least didn't cite in the decision, this entity is by law independent. The statute uses that word, independent of any executive branch control.
I'm sorry, your red light is on. Could you just take a moment to address waiver?
Certainly, Your Honor. We claim waiver in three different respects. One, by operation of a multi-million-dollar business, transportation business that is likely to cause injury in the state of New York. There was one cited authority for the proposition that operating a business doesn't waive the jurisdictional impediment. It isn't a consent to jurisdiction. That case didn't deal with this at all, the savings bank case versus Florida prepaid. That case dealt with the issue of whether Congress can force a waiver when an entity enters into a particular field, in that case, making loans, and did that render them subject to the Lanham Act. But this is a case where the state has waived its immunity. The question isn't whether they can be forced to waive their immunity. They waived it in the Tort Claims Act, Section 2.2, Subdivision A. The question is, when it has waived its immunity, can it still assert interstate immunity as to the very actions for which they waived immunity? The second way in which we say they waived immunity is by New Jersey itself. When New Jersey passes a statute that says this is not the state, anything that can be sued any entity that can sue and be sued, with the exception, partial exception of the Palisades Interstate Authority. Any state that can sue, any entity that can sue and be sued is not the state. That, how more clearly can it be a waiver of interstate immunity? This legislature is telling us it's not a state, at least for the purposes of the Tort Claims Act. And they're waiving immunity for the purposes of the Tort Claims Act. And the third is by their actions in this case. This court last year in Henry decided that this interstate immunity defense isn't like, it's not a matter of subject matter jurisdiction. It's more akin to in personam jurisdiction. Of course, in personam jurisdiction is easily waived. The commentary to 32...
They argue there had not yet been a trial, and in part, that's the dividing line. Why aren't they right about that?
Well, the question was what happened between these two points. This suit was commenced in September of 2017. The motion was made in July of 2020, just a bit shy of 3 years. The limited discovery, so-called, was 9 so-ordered stipulations from 9 discovery conferences during that almost 3-year span. During all that period of time, they could have moved for dismissal at any point. They did not. And even when you look at their so-called pleading...
Did they gain an advantage by not doing so?
Well, certainly, we gained a detriment by not doing so, and that the statute of limitations has run in New Jersey. And what's happening consistently in all these transit cases in New York is they resist not only the jurisdiction here, but any finding that they've waived it, the statute of limitations back in New Jersey.
Well, counsel said it's equitably tolled, or maybe equitably tolled. Do you disagree?
Actually, that's the first time that was mentioned, and I'm not familiar with it, Your Honor. In all the cases that I've seen, the New Jersey transit cases, that's not been mentioned. It wasn't mentioned in the briefs here. And I'm just not familiar with it, Your Honor. When you look at the pleadings, they pleaded lack of jurisdiction over NJT, not interstate immunity, not 11th Amendment immunity. They claim this court lacks jurisdiction, which speaks, I think, to subject matter jurisdiction, and that they're immune from suit. There was no indication anywhere in their pleading by what immune to suit, what they meant was they're not immune to suit, but they're immune to suit here in New York. Nothing to convey the notion that the problem isn't that they're immune, but the problem is they're immune in New York, supposedly. That wasn't pleaded.
Thank you, counsel.
Thank you, Your Honor.
Counsel, can I ask you 2 questions about Hess? One is, what's your view about whether the test in Carnes and or Mancuso, if you think the distinction matters, best furthers the goals set forth in Hess? And what do we do about the fact that Hess is a compact clause case? Does it affect the way we think about the arm of the state test?
Sure. Hess goes to the question of dignity of the state because it is a compact case.
Yeah.
So there they said that it's not a single state, it's 2 states, and the fact that the 2 states had entered into a compact approved by Congress lessens the dignity of the state issue, and therefore, made it easier to find a waiver of sovereign immunity. So Hess did not in any way turn on the fact that it's a common carrier or that it's the Port Authority. It was really turning on the fact that this was a compact case. In terms of the test that should be applied...
So on that, so we should not take away from Hess anything relevant to the factors for the arm of the state test if it's not a compact clause? That's what I was trying to get at.
Sure. I think what Hess makes clear is that the 2 issues it turned on were first that the compact matter, and second, with respect to finances, that you need to look at the practical impact of the impact on the fisc. There, the Port Authority is set up as a completely independent, both in terms of control and in terms of finances. So by negative implication, that's relevant to our case where New Jersey Transit is not set up independently, either financially or in control. New Jersey Transit remains subject to appointment
Sorry,
by the...
I don't want to run up
course.
against your red light. Carnes and Mancuso, does the difference matter, do you think?
I think since Carnes is the Third Circuit and is directly on point, it's the federal court that has jurisdiction.
Okay, and
over
if we don't view ourselves as bound by the difference, does it matter in terms of the goals of what the 11th Amendment is looking to protect?
I think those cases are pretty much approaching it the same way, using two different tests under the 11th Circuit. And as applied directly to this party in Kearns, the Third Circuit reached the decision that the New Jersey Transit is the arm of the state.
Mm-hmm.
And so, to get back to the broader point,
Is it your view that the analysis under Hyatt 3 expands, let me put it that way, the actors who might fit within the state for purposes of sovereign immunity, as compared to the 11th Amendment?
yes, potentially, because the 11th Amendment is limited to federal court, whereas the sovereign immunity recognized in Hyatt goes beyond that, and also because the court in
Well, that
Hyatt...
doesn't mean the actors expand, that means
Yeah,
the
but to-
venue, a different
But to
question.
continue, I think because Hyatt so strongly stressed the fact that this is fundamental to the constitutional compact and is an explicit limit on the state's ability to deny sovereign immunity,
Yeah.
I think it does potentially expand the universe of plaintiffs.
Of course,
or
the type of administrative framework we now have was not envisioned at the time of the Constitution or predating the Constitution, so perhaps not. Perhaps this really is just the state.
Well, to look at, I think, the, another portion of the Constitution, which is the full faith and credit clause. Here, the issue is not just hypothetical, as Judge Guerrero suggested. It has explicitly been decided by the state of New Jersey. It was decided in the Public Transportation Act, 2725, and it was decided explicitly by the highest court of New Jersey in the Muhammad versus New Jersey Transit case,
Okay,
which
let me put
removed
aside,
any
let's put
doubt.
aside for one moment the judicial decisions. Let me ask you a different kind of question. Can a state itself declare what entities fall within this Hyatt 3 sovereign immunity analysis? Because it expand its own protections, let me put it that way.
I would say yes with a caveat. The state's legislative act of declaring that New Jersey Transit is a part of the state, and the Tort Claims Act is a bit of a red herring. I can come back to that if you like. But the state has explicitly said that this is a part of the state. Once it does that, that's entitled to full faith and credit. You can imagine a scenario where a state says, okay, we're just going to immunize everything that anyone does in New Jersey. And there, I think you would have a separate kind of a case where full faith and credit might
It's a
not
little
be
different
warranted.
question. It's whether New Jersey could immunize whatever New Jersey does in New York. So New Jersey opens up a shooting gallery with live ammunition in Times Square and says that's an arm of the state. Does that work?
I think there you might have a very difficult case, and I would not want to be arguing that case for the state of New Jersey.
But why is that? The questions were turning on whether or not the state itself can define the contours of that sovereign immunity. And who can rely on it, who can invoke it, or what can invoke it,
The
excuse me.
reason I would have more trouble in Judge Guerrero's hypothetical.
It's actually-
Referring to me when you say Judge Guerrero?
Sorry, am I getting the names wrong? I apologize. But the
I
reason
think
I'm
they're on
having,
your sheet if you look down.
In front of you, you gotta
thank
see
you.
it.
The reason
might
I
be
was having
helpful.
trouble with Judge Wilson's hypothetical is that if you look at the arm of the instructive cases under the 11th Amendment on arm of the state, they talk about questions of control, questions of traditional use of executive power, things that look and act like the state. A shooting gallery does not look and act like the state, so I think there would be a much more difficult decision to be made there. Here, however, New Jersey Transit has the police authority. It has eminent domain authority. It is subject to...
So is the rule that the state's statutory designation has to be given complete deference if it's what? What exactly is the cabining principle you're articulating there? If it is something that quacks like a state? I'm not trying to be flippant,
No, of
but if
course, of
it's something
course.
that, you know, we would generally recognize as an essential state function. Is that what you're suggesting?
The full faith and credit clause requires that states defer to the legitimate legislative and judicial acts of their sister states. I think if there were, as in your hypothetical, reason to question whether that was a legitimate act of the state, then there might be an argument that the full faith and credit act clause does not apply. Here, all of the indicia, and they're cited in our case, they're cited in the Muhammad matter, they're cited in the Kearns matter, all of the indicia are that New Jersey legitimately has named the New Jersey Transit Authority as an arm of the state because it is subject to the control of New Jersey, because it is performing a traditional state function, because under all of the indicia as recognized under state law, that is a legitimate act of...
Public transportation is public. Can you just quickly say whatever your comment was regarding the Tort Claims Act being a red herring?
Oh, yes, the Tort Claims Act, the appellant, or appellee cites the one provision which says that the state shall not be included in such entity under the Tort Claims Act. But that's been explicitly addressed in Muhammad and other places. There's another portion of the New Jersey Tort Claims Act that refers to public entities more broadly, including the state and other public authorities. And the point is that New Jersey Transit is a sue and be sued state authority under New Jersey law. So it's outside of the particular provision that is being cited by my opponent in this matter. But it has been explicitly recognized to be an arm of the state for the purposes of the Tort Claims Act.
Thank you.
Thank you, Your Honors.
Your Honor, a point of information not relating to the merits. This
can
issue is
send-
going to be
you-
argued tomorrow in the Supreme Court of Pennsylvania.
You can send us a letter afterwards if you like.